We were discussing the conservation of forest and wildlife, which is a topic which is there in the fourth module of our syllabus. And we started with an introduction. What is forest? What are the importance or significance of forest? Why forest is to be conserved? Then we saw the different significances of forests, like industrial significance, significance to the tribals in order to maintain the ecological balance. All those things we've already completed. Then we saw the history which is behind the conservation of forest. We started with the ancient history, wherein we saw forests were considered to be very important, very pious, and they were treated as gods and goddesses by the ancient Indians. Then we moved on to the British period, what all developments took place after the advent of British. We saw there was a ruthless exploitation of the forest all throughout the British period. And next, we'll have to look into the first statute. Though there were statutes even prior to this, this was considered to be the first consolidated statute for the protection of forests in India. And it was enacted in the year 1927, and it still continues to be in the statute books. Okay. So today we'll be discussing two major statutes. One is Indian Forest Act 1927 and second is Forest Conservation Act of 1980. So to begin with Indian Forest Act 1927, the main objective or aim behind the statute is to consolidate the law relating to forests, the transit of forest produce, and the duty that can be levied on timber and other forest produce. Okay, so first thing you need to remember is this was a statute which was enacted by the British. And obviously, when you analyze the ultimate purpose and objective of this particular statute, you can see that it was all intended to benefit the British. And this act gives ample powers to the state governments to exercise control over the forest. So, state governments were given a lot of power under this statute, especially with regard to the transit of forest produce, the permission to be granted, then duty can be levied on timber as well as other forest produce. All these powers were given to the state government under this particular statute. And the structure of the statute is like this. It comprises of 8 chapters with 82 sections. And the most important factor to be noted here is the statute divides forest into 4 categories. One is reserved forest under section 3 of the statute. Second is protected forests under section 29. And third is village forest under section 28. And finally, private forest under section 35. So the entire act, when you analyze, you can see it speaks about what is to be done with regard to this reserved forest, what is to be done and what cannot be done with regard to protected forest. So each and every category of forest, there are certain do's and don'ts. So there are certain prohibitions. In certain cases, you can see certain regulations. In certain cases, you can see no regulations at all. So likewise, what all things can be done with regard to these different categories of forest? That is the first thing. And second thing, how they classify the forest into these categories and what is the procedure to be followed while categorizing or classifying the forest as a reserved forest, protected forest, village forest, etc. So first we'll discuss the provisions with regard to reserved forest. Sections 3 to 27, which falls under chapter 2 of the statute, talks about the reserved forest. And it says that the state government may constitute any forest land or wasteland which is the property of the government or over which the government has proprietary rights, or to the whole or any part of the forest produce of which the government is entitled as a reserved forest. So a few things are to be noted here in this section. One is it is the state government which has the power. The state government, and the word used is may constitute. So it is not mandatory that state government should do. It is a discretionary power which is vested with the state government to constitute any particular land, which is a forest land, or it can be even a wasteland. Or one more thing you need to remember here is it can also be a forest produce. It need not be a forest at all. And the term forest produce is also defined under the statute, and you can see what all things, a lot of small things which you can see in the forest is included in the definition of the term forest produce. It can be even glue or some timber. So a lot of things are included under the definition of forest produce, those things which are found only in the forest. Okay, so the state government may constitute any forest land or wasteland which is either the property of the government or over which the government has certain proprietary rights, and it can be over a whole area of forest land, or it can be only a part of the forest area, or it can even be with regard to certain forest produces of which the government is entitled. And such area or such forest produce may be designated as reserved forest under section 3. And section 4 onwards speaks about how this has to be done. This particular declaration has to be made. And firstly, a forest settlement officer will be appointed, and he'll have to see if there is any claims which is there with regard to that particular property. Then he'll have to mark the boundaries, and if there is any claim by any private person, that has to be entertained first, and finally there will be a notification which is issued by the state government which says that yes, this particular property which comes within this boundaries will be declared as, or is being declared as, reserved forest. So what is the impact or implication of reserving a particular area as a reserved forest? That it means that it will be strictly regulated under the control of the government. So nobody else has any authority over that particular property which is designated as reserved forest under Chapter 2 of the Indian Forest Act. So it belongs to the government alone. And the government is entitled to own all or any part of the forest produce in the reserved forest. It need not be the land as it is. It can even be the forest produce over which the government can exercise its powers. And once it is reserved as a reserved forest, declared as a reserved forest, then no right could be acquired over reserved forest except by succession, grant or contract by the government or by any other person having pre-existing rights. So generally what is being done is, before notifying, they'll clear all the uh, claims, etc., and no right could be acquired over reserved forest. That means that part of the forest land or that forest produce will be solely the government's property. Now we'll see what all activities are prohibited in a reserved forest. So it is mentioned under section 26, and you should understand that a reserved forest, that category is the most or the category where most prohibitions are being mentioned. Okay, so what all activities are being prohibited? A few have been mentioned here: clearing of trees, setting fire to the forest, fishing, burning of charcoal, hunting, trespass or pastures any cattle, permitting any cattle to trespass, felling any tree, cutting, dragging any timber, burns any tree, strips off the bark of leaves, damage the tree, quarries the stones, collect or removes any forest produce for the any manufacturing process, clears or breaks up any land for cultivation or any other purposes, poisoning water, or sets trap or even kills or catches elephants, etc. So almost everything is prohibited in a reserved forest. You cannot cut the trees, you cannot set fire to the forest, you cannot fish from the waters, you cannot set traps and kill elephants or catch elephants. You cannot hunt any animals. You cannot burn any tree. You cannot take the barks or leaves of the tree. So almost everything is being prohibited in a reserved forest. That means the implication is that everything, every forest produce which is there in the forest, it belongs to the state government. State government can take it as it is required. No private person can go to the forest, especially if it is demarcated as a reserved forest, and do any of these activities. These activities are strictly prohibited in the reserved forest. There is no regulation or anything. It is completely prohibited, and any violations pertaining to the prohibited activities shall attract punishment, and the punishment is mentioned as imprisonment, which may extend up to 6 months, or a fine which may extend up to rupees 500, or both, in addition to such compensation for damage done to the forest as the convicting court may direct to be paid. So if at all you are doing any prohibited activities in the forest area, reserved forest area, you are liable to be punished with imprisonment or fine or both. Next, we'll move on to the village forest. Village forest is mentioned under Section 28 of the Indian Forest Act 1927. It says that the state government may assign to any village community the rights of the government over any land which has been constituted as a reserved forest. So, the rights which are accrued upon the state government when it is notified as a reserved forest, that may be assigned by the state government to any village community. It can be given to any particular village. And Section 28 Clause 1 enables the state government in this regard to cancel or denotify any reserved forest and assign the rights of the government on that land to the village community. So once uh, a particular forest area which was notified as a reserved forest may be assigned by the state government to any particular village. Okay, they can assign the rights over that particular reserved forest to any villages, and it can be either through denotification or cancellation of the earlier notification. And clause 2 of section 28 states that the state government has power to make rules regarding the regulation of village forest management. So what is the purpose behind giving this reserved forest area with the management of a village community? That is again for managing the forest. It is not for exploiting the forest. So what is to be done here is this: the state government generally makes rules again which regulates what is to be done with the village forest or what not, what all restrictions are being imposed. So those things are to be specifically made into a rules with regard to the management of such village forests. And in pursuance of this power, it may prescribe conditions with respect to the supply of timber or other forest produce or pasture to the community to which such an assignment has been made. So if at all one particular reserved forest has been re-notified as a village forest and has been entrusted with the management of a village community, then that village community will be given the rules. The state government will be drafting or enacting the rules as well with regard to what all produces can be taken from the particular forest. If at all you need to pasture your cattle and all, what is to be done, which all areas can be used for that. So everything will be laid down in the rules. So the state government can frame rules to give some rights to the village community. So everything depends upon the rules which is made by the state government. And all regulations applicable to a reserved forest are applicable to village forest also. But only thing is that if there is a contrary rule, then that provisions of that rule will be applicable. That's what is mentioned here. So all regulations applicable to a reserved forest are applicable to a village forest also, to the extent to which it is not contradictory to the rules made by the state government for the specific purpose of regulating village forest. So it is again the prerogative of the state government to make rules which either gives certain rights or which pertains to the management of such village forests, etc. So that rule will prevail if that is not contradictory to the uh, if the provision which we saw earlier, that is section 26, does not is not contradictory to the rules which is made by the state government, then the provisions of section 26 also automatically applies here. And along with the rights, certain duties for the protection and improvement of such forests may also be laid down for such communities. So basically this is intended to give powers or rights for the village communities, and this is actually for the management of forests in a proper way. The next category is protected forest, which is mentioned under section 29 to 34 of the Indian Forest Act 1927. Section 29 defines the term protected forest as any forest land or wasteland which is not included in a reserve forest, but which is the property of the government or over which the government has proprietary rights, or to the whole or any part of the forest produce to which the government is entitled. So just like the reserved forest, so here also the forest area under the control and ownership of the state government, which is not a reserved forest, which has not been reserved as a reserve or notified as a reserved forest, it can be classified or categorized as protected forest by the state government. And such forest land and wasteland notified by the state government in the official gazette shall be called as protected forest. And what is the difference between the reserved forest and protected forest? Yes, of course, protected forest also is under the ownership and control of the state government, just like a reserved forest. But the amount of control and restrictions which is imposed on the protected forest are lesser when compared to the restrictions on the reserved forest. In a reserved forest, almost everything is completely prohibited there. But here, the state government can regulate activities in a protected forest. It is not mandatory and it can do in certain aspects, not as strict as the reserved forest. It can be even the protected forest can be notified or the notification can be issued with respect to a particular forest land, or it can be a wasteland which is under the proprietorship or ownership of the state government, or even here also it can be over certain forest produces alone. Okay, and here also the state government can regulate. You should differentiate between the terms used. In the protected forest, the term used is regulate the activities, whereas with regard to the reserve forest, it is complete prohibition of the activities mentioned therein. Okay, so here state government is empowered to regulate the activities in protected forests. Let us see the next classification, that is private forest, which is mentioned under section 35 of the Indian Forest Act 1927. Private forests are forest land which is owned by the private persons, and these forests are not the government's property. And this particular category of forests are mentioned in chapter 5, sections 35 to section 38 of the Act. And here what is the power or authority of the state government? Here also the state government may regulate or prohibit certain activities even if it is under the ownership of a private person. And what are such activities? It can be like breaking up of or clearing of land for cultivation, pasturing of cattle, firing, then clearing of vegetation, etc. All these things can be regulated or prohibited by the state government, and it should be done only for a certain purpose. And what is that purpose? It should be for the protection of such forest against storm, wind, rolling stones, floods, etc. Or it can be for the preservation of soil, protection of land against erosion, etc. So private forests are essentially forest lands owned by the private persons, and there also the state government may regulate or even prohibit certain kind of activities, especially for the purpose of preservation or protection of such forest area. So there are other few provisions in this particular statute which are important. One is section 30. It says that the state's government may declare any trees or class of trees in a forest to be reserved. So it need not be a reserved forest or a protected forest, but a class of trees or any particular tree to be reserved by the state government, and that is also possible under section 30. And section 41 empowers the state government to make rules to regulate the transit of forest produce. So in order to move the timber or other forest produce, the state government may make specific rules to regulate the same. And the central government is also empowered in this respect to levy duty on all timber or other forest produce. If at all you are taking some timber or some other forest produce from the forest, the central government may even levy duty on such timber or other forest produce. Now let us see what are the drawbacks with regard to the provisions of this Indian Forest Act of 1927. Firstly, very plainly, it can be said that this act never aimed to protect the forests in India. It was enacted by the British, and their intention was just systematic exploitation of forest and forest producers, including timber. And this statute was enacted to regulate the cutting of trees. That means the monopoly was given to the state government so that no other private person was allowed to cut the trees, and to earn revenue from cutting of trees and forest producers. And that revenue or earning of such revenue is to be done by the state government alone, not the private parties. And it deprived the tribals their rights and privileges to use the forest and forest producers. So in this statute, you cannot see any provision specifically guaranteeing or granting any rights, basic rights for the inhabitants of the forest, that is the tribals. Then it mainly aimed at supplying the raw materials for forest-based industries. So the ultimate object of the statute was to supply raw materials for the forest-based industries, especially the requirements of the state government, that is the British government, that is shipbuilding, then laying railway lines, manufacturing of railway coaches, etc. And its attitude was entirely revenue oriented attitude, and it failed miserably to protect the forest from unscientific and unplanned exploitation. The most significant aspect of the statute is that the forests were declared to be the property of the government. So when the government is vested with the complete ownership and proprietary rights of that particular forest land, that means nobody else can have access to the forest resources in that limited area. And in case of disputes, the official who was assigned was the forest settlement officer, and he has the full authority to determine the extent of the rights relating to grazing, use of water resources, cultivation, or use of forest produces. And when you analyze the statute, you can see that the punishment which is prescribed is also very less punishment, that is imprisonment which may extend up to 6 months, or a fine which may extend up to rupees 500, or both. And the act demonstrates the exploitative intention of the colonial state, and the revenue generation was the ultimate objective. And one change which was brought about by the 1982 amendment of the statute was that greater powers were given to people who are domiciled in the forest, that is the tribals and other indigenous people. They were given some powers with respect to the use of forest and forest produce, and this was inserted by the 1982 amendment. Now let us see the constitutional provisions for the protection of forests in India. We have discussed it many times before also. 42nd Amendment to the Constitution, in which the forest and wildlife was shifted from list 2 of the 7th schedule to the list 3, which is the concurrent list. And now forest and wildlife forms entry 17A and 17B of the concurrent list. And the implication is that the central government as well as the state governments are empowered to enact laws for the implementation or the protection of forest and wildlife. And Article 48 inserted into Part 4 of the Constitution, which directs that the state shall endeavor to protect and improve the environment and to safeguard the forest and wildlife of the country. The directive principle, which directs the state government to make laws and policies to protect and improve the environment and to safeguard forest and wildlife of the country. Along with that, Article 51G, that is a fundamental duty of citizen to protect and improve the natural environment, including the forests, lakes, and wildlife. So that means the Constitution also gives special importance or significance to the aspect of protection of forest and wildlife. So now we saw the conservation of forest during the British period, the statute which was enacted by the British, that is the Indian Forest Act of 1927. After that, India got independence, constitution was drafted, and as it was enacted, there was no provision pertaining to the protection of forest and wildlife. But later in 1976, the constitution was amended and Article 48A and 51G was inserted, and you can also see the most important provision, that is list forest and wildlife was taken from list 2, which was the state list, and it is inserted under list 3, so that now forest and wildlife is a subject in which both the center as well as the state governments can enact laws. Now let us see the next important statute, that is the Forest Conservation Act of 1980. And this is considered to be a very remarkable legislation in the history of forest conservation in India. And with the transfer of the item or entry forest from list 2 to list 3 of the constitution, it gave powers to the central government to act directly in managing India's forest. So till that time, till 1976 amendment, it was the state government who was empowered to enact laws for the protection of forest in India. But after the amendment, even the central government is empowered to enact laws for the protection of forest. And in pursuant to such a power, central government enacted this particular legislation, that is the Forest Conservation Act in the year 1980. And what prompted the central government to to enact such a legislation was large scale deforestation, which was rampant and which was leading to environmental deterioration. And this resulted in the central government taking such a measure. And this Forest Conservation Act is such a small statute which contains only 5 sections, but it is considered as a watershed legislation which has been extremely effective and successful in conserving forests. And the objectives of this Forest Conservation Act are twofold. One is a restriction on the use of forest land and forest land for non-forest purposes. So if it is a forest land, it shall not be used for non-forest purposes. Say for example, cutting the forest and making it land for agriculture, cultivation. That is one non-forest purpose. So you have to maintain the forest land as it is, and you are not supposed to use the forest land for any non-forest purposes. That is the first objective. Second objective of the statute is control of de-reservation of forests that have been reserved under the Indian Forest Act 27. So go back again to the Indian Forest Act. What was the ultimate aim? It was to reserve certain areas or notify certain areas as reserved forests, so that the state government is vested with exclusive powers to take the resources from the forest. So that was done during the British period, and British did this with an intention to exploit the forest producers for their personal benefits. But when we got independence and now forest conservation is something which is very important for the progress of the country, we are trying to prevent or control the de-reservation of forest, opposite of reservation of forest. So once the forest has been already termed as reserved forest, the central government is not allowing to de-reserve such forests. And now the intention is to protect and conserve the forest. So that is a shift from the colonial rule to our own constitution and our own rule which is established in our country. So earlier, why did they reserve the forest was only for the purpose of exploitation of the forest. And right now we are not allowing to de-reserve the forest is also with the same object behind it, that is to protect and conserve the forest. So with the enactment of Forest Conservation Act in the year 1980, the central government has been given wider authority over the state governments. And this act specifically provides for, as I've already mentioned, restriction on the de-reservation of forest or use of forest land for non-forest purposes. So right now, the state government cannot de-reserve a forest area which was earlier designated as a reserved forest, and also they cannot use the forest land for non they cannot give sanction or license for the use of forest land for non-forest purposes. And the statute also transformed the central government into the guardian of forest protection. And the assumption is that the guardian will act only in the interest of safeguarding the forest environment. And one major amendment which took place in the year 1988 was that to include provisions to restrict leasing of forest land. So, with 1988 amendment, the leasing of forest land was also restricted, and to prevent felling of naturally grown trees. So, these are in essence the provisions of the the Forest Conservation Act of 1980. So as we have seen earlier, the Forest Conservation Act makes prior approval of the central government mandatory for the use of forest area for non-forest purpose. I've mentioned this in the previous slide also. And what is this non-forest purposes? It means breaking up or clearing of the forest for cultivation of tea, coffee, spices, rubber, palms, oil-bearing plants, horticultural crops, or medicinal plants. So, in order to cultivate any of these things, if the forest area is being cleared, then it is considered to be for non-forest purpose, which is not generally permissible under the Forest Conservation Act. And if at all you will have to do that, it needs the prior approval from the central government. However, the clearing of forest for reforestation or any other work for conservation and management of forest and wildlife does not amount to non-forest purposes. So only this is required only if it is for non-forest purposes, and if it is for any reforestation, that is growing new forest and all, then the approval from the central government is not mandatory. And the Forest Conservation Act makes prior approval of the central government mandatory for the state governments to denotify a reserved forest. So once a forest area has been notified as reserved forest, and if the state wants to denotify such an area, then also the consent and prior permission from the central government is mandated. That means for all the major changes that can be done on the forest area, it has to be done only with the prior approval of the central government. Very interesting aspect with regard to the protection of forest, conservation of forest in India. It's the judicial attitude towards the conservation of forest. So when we discuss this topic, one major decision of the Honorable Supreme Court, that name is to be remembered forever. It is T.N. Gothavarman Tirumulpad versus Union of India. You can see various number of citations in the same name. Various cases has been reported in the same name, T.N. Gothavarman Tirumulpad versus Union of India, in various years. And let us see the history behind this case and how this case has influenced the entire conservation of forest in India. So the Supreme Court has played an important role in widening the meaning of the term forest for the purpose of forest laws. So in the first case, that is T.N. Gothavarman Tirumulpadu versus Union of India, reported in AR 1997, where the state governments were interpreting the meaning of the term forest very narrowly to include only reserved forests, and they were going ahead with denotification of other forests for non-forest purposes. I hope you know the terms reservation of forest, dereservation, then non-forest purposes, etc. I've been discussing these terms in the previous slides also. So here the state governments, they actually had the whole power to notify a particular forest area as reserved forest. But with the commencement of 1980 Indian Forest Act, that power has been curtailed. So for de-reserving a particular reserved forest area, the state government should get the permission and prior approval from the central government. Here, what did the state governments did was they interpreted the meaning of the term forest to include only reserved forest. So whatever they are doing, they cannot, whatever limitations they have is only with regard to reserved forest. That was their argument. And they were going ahead with the denotification of other forests. That is, it can be village forest or protected forest, etc. for non-forest purposes. And I hope you know the meaning of the term non-forest purposes. It is clearing the forest for the cultivation of tea, coffee, etc. So the Supreme Court held that the term forest must be understood according to its dictionary meaning and that it covers all statutory recognized forests. So contrary to the argument put forward by the state government, the Supreme Court said that no, when you talk about the forest should be understood in its plain, simple dictionary meaning. It doesn't mean that the term forest includes only the reserved forest. Okay, so the Supreme Court, they said that the term forest must be understood according to the dictionary meaning and that it covers all statutory recognized forests. That means it includes reserve forest, it includes private forest, it includes village forest, and it also includes protected forests. And it was observed that the term forest land will not only include forest as understood in the dictionary sense, but also any area recorded as a forest in the government records irrespective of ownership. So the question of ownership is not at all a concern. If that particular area has been classified or recorded as a forest area in any of the government documents, that is to be considered to be a forest area. And court's intervention brought all forests within the purview of the term forest for the purpose of the Forest Conservation Act and thus prevented such misuse of legal provisions by states in denotifying the forest areas. So denotifying the forest areas was the power of the state government prior to 1980 Act. But with the 1980 Act, that has to be done only with the prior approval of the central government. And what the states did was they narrowly construed that meaning and they told only with regard to reserved forest, dereservation requires the permission of the central government. Other forest area can be denotified or dereserved. But Supreme Court said no, nothing doing. Forest, whatever type of forest it is, even if it is a private forest, it cannot be dereserved. So who was this T.N. Gothavarman Tirumulpad? He was a member of the royal family of Nilambur Kovilagam, that is an area in Malabar or northern Kerala. And this case, which was initiated by him, is considered to be a landmark in the context of the legal regime for the protection and conservation of forests in India. And this is considered as a watershed case. Like there is no precedence in Indian legal history like this particular case. And the Supreme Court reoriented licensing and functioning of forest-based industries. A lot of orders were issued by the Supreme Court in this particular case, and let's see how it was done. More than 1,000 interlocutory applications have been admitted in the same case, and several hundreds of orders have been issued, many with far-reaching implications. So whatever issue comes up with regard to the conservation of forest, that was considered as an interlocutory application under the T.N. Godhavarman Tirumulpadu case, and the case is still pending before the Supreme Court. And in the process, court has gone far beyond its traditional role as interpreter of law and assumed the roles of a policy maker, a lawmaker, and an administrator. Through a series of orders, the Supreme Court of India controlled or prohibited a number of activities affecting forest ecology. So if you start reading T.N. Godhavarman Tirumulpadu case alone, you can see the number of orders issued by the Honorable Supreme Court in favor of the protection and conservation of forests. So all these comes under the same name and title of the cases T.N. Godhavarman versus T.N. Godhavarman Tirumulpadu versus Union of India. Among the n number of decisions given by the Honorable Supreme Court in the same case of T.N. Godhavarman Tirumulpadu versus Union of India, a few important orders have been listed out here. It is not an exhaustive list, it's just a few, very few number of or a very few instances where court has interpreted the forest laws. One, it was held that running of sawmills and mining of minerals are non-forest purposes requiring permission from the central government. In another instance, the Supreme Court banned felling of trees in the tropical evergreen forest in the state of Arunachal Pradesh. Another instance, movement of cut trees from any of the 7 northeastern states to any other states was banned. And Supreme Court even introduced various afforestation schemes. And when forest land is used for non-forest purposes, provisions must be made for compensatory afforestation also. If in case the forest area has to be used for some cultivation purposes, then there should be a compulsory afforestation which is to be made by such persons. And the court even suggested that the user agencies ought to pay compensation on the basis of net present value. It is in short known as NPV of the land diverted for non-forest purposes. So these are very few important decisions or orders given by the Honorable Supreme Court in the Tirumulpadu case, which actually pertains to the conservation of forests in India. Now, how did the Supreme Court do all these things under one single case? It is in jurisprudence, it is non-constitutional jurisprudence, it is known as the writ of continuing mandamus. And the Supreme Court did not close the matter and it kept open for more than 2 decades. And more than 1,000 interlocutory applications have been filed in the same case covering a spectrum of issues concerning forest protection such as mining, tree felling, management of protected areas and even forest encroachment. And in response to the rising number of interlocutory applications and the technical nature of the issue involved, the court ordered the constitution of an expert body, that is the Central Empowered Committee, in short a CEC, was constituted by the Supreme Court in the year 2002. And in September 2002, it was notified as a statutory committee with wide-ranging powers to deal with pending IAs, hear fresh applications and pass orders in consonance with those of the Supreme Court. So that means the Central Empowered Committee, which is constituted by the Honorable Supreme Court, is solely in charge of hearing the pending IAs or even hear the fresh IAs and pass orders which are in tune with the orders given by the Supreme Court in cases related to the conservation of forests. So this particular case is considered to be a new paradigm in the administration of forest that has been created. And this case also, just like any other cases, it's not free from any criticism. It says that the judiciary has gone beyond its limits and this is a clear example for excessive judicial activism. But when you take into consideration the most important aspect, that is the significance of conservation of forests, you can say that since the executive authorities has not taken care of properly, judiciary had no other option but to bring in these important orders with regard to the conservation of forests. So with that, we completed with the protection of forest in India. We dealt with the statutes which came up even before we got independence, that is Indian Forest Act of 1927. Then we saw the constitution be enacted, and in 1976 when the constitution was amended, specific provisions were introduced into the constitution for the protection of forest and wildlife. Then we saw the remarkable change which took place in the legal regime for the protection of forest, that is in the Forest Conservation Act of 1980. And we also discussed the most important case with regard to the conservation of forest in India, that is T.N. Gothavarman Tirumulpadu versus Union of India. And I told you this case it is still open, and it was for almost 20 years. This has been kept open, and a number of decisions has been rendered by Honorable Supreme Court on the same subject matter, on the same title. And with this, we conclude the laws in relation to the protection and conservation of forest. In the next session, we'll continue with the protection of wildlife. For that, we have one major statute, that is Wildlife Protection Act, and we'll deal with the details of that statute in the next class. Thank you.